And lastly, dissolution of companies. What does the law provide for? Is there a place where it's just a going concern that there's no dissolution?
Dissolution of companies, again, that is something at the time when you're starting the company you should agree. Because one thing, again, is that a company doesn't die.
Yes.
You see, a company doesn't die. That's the difference between a sole proprietorship and a limited company. So a sole proprietorship, when you die, it is gone.
Yeah.
But a company outlives you.
Yes.
So depending on how you have provided in the we call them MEMATs, the Memorandum and Articles of Association, and your agreement, depending on that, that will determine how it will be dissolved, how properties will be sold off, how it can come to a closure.
Yes.
Yes.
Is it something that has to be in the Memorandum of Understanding, or it can be even in the bylaws of the company? How strong are bylaws of a company?
It really depends on the structure. It really depends on the structure in this particular case, because one is a reflection of the other.
Yeah.
Yes.
Yeah.
And maybe, for example, many times, I mean, law we usually say the one that comes later supersedes. And there's a way when you draft, when you're drafting a document, you're saying this takes effect from today, and anything that was before today ceases.
Yes.
Just in common language, I'm trying to put it in very simple language, whereby by the time you're coming up with a contract on a later day, then you're trying to say any contract that was there before has no validity. This one that has come late is now what takes precedence. Yes.
Then on the process of company
dissolution of the company.
Dissolution of the company, how does it go?
Dissolution of the company, as I told you, is a process.
Because there is a misnomer where a company is supposed to be a going concern, but at some point it could call for the dissolution.
It would call for the dissolution. And actually the reason why, if you decide you don't want to have anything more to do with the company, it's just good to go through the whole process and make sure that it's no longer existent. Because it's no longer existing, because sometimes people again will take advantage of that gap. We know how the world is, and probably reactivate it, and you remain their shareholders, and these people go and borrow elsewhere and do funny things, and in one or the other you become liable. So once you have decided that you no longer need this company and it's coming to a close, there are specific, you should of course sit and have your minutes, have the resolution and have that, and file the relevant documents at the company registry. There is a process that it will go through, and at some point it will be gazetted to be shown that now it has actually been dissolved and it's no longer existing. We have different companies again whereby they are being dissolved due to insolvency, which means they are bankrupt, they've not been able to pay up their debts and all that. That one is done through petitioning, and that one has to go through the court. And that is where, again, the element of the different shareholders come in, how the debts are paid up. Those are other rigors that specific lawyers now, as you sit with them now, you can go through the process. Yes.
Okay.
Yes.
Thank you very much. I think we have covered most of it. We appreciate you hosting us and having this conversation. We hope it's going to enrich our viewers who are entrepreneurs. We ask them to comment there, like, let's hear from you and what you would like to hear next.
Thank you very much for having me.
Yes.
I hope I've been able to shed some light. I've tried to keep it very simple, not get into too much legalese, so that the entrepreneurs can understand. But also now where they don't understand, they can reach out to us.
Very well.
And then we can sit and deliberate and make sure that they grow to higher heights.
Sure.
Yes.